Good morning, Judge Shapiro. We do currently have everybody ready to bring in whenever you're available. Judge Shapiro, I don't know if you can hear me, but it looks like your video has frozen. There we go. It looks like I can see you. And is your sound working?
Pardon?
I don't think I can hear you. It looks like
I'm on unmute. Here we go. Let's see.
it looks like you've muted yourself, but the sound was getting a little better.
Okay, can you hear me now?
Yeah, we can hear you now. I can bring the parties in when you're ready.
Yeah, you can do that.
Morning, Judge.
Good morning, Mr. Ocho. And it's is it Del Mastro?
Yes, Your Honor.
Thank you. Mr. Wiley. And well, let's just go around and everybody tell me who they represent. Let's start with Mr. Acho.
Good morning, Your Honor. I represent plaintiff Dana Telep and also the second case, John DeMarais and Paula Hunton.
You
Also,
represent all three plaintiffs.
I'm sorry, Your Honor.
Then all three plaintiffs?
Yes, sir.
All right, Ms. Del Mastro. Who do you have?
I represent all defendants.
All defendants. Okay. In both cases.
Correct, Your Honor.
Can you hear me okay? Okay, good. All right, and then we have Mr. Wiley.
John Wiley, also representing all plaintiffs with Mr. Acho.
Okay. All right, Mr. Howlett?
Yes, Your Honor. Thank you. Timothy Howlett, and I represent both defendants, and I will be handling the arguments today.
Okay. And Ms. Roberts?
The court reporter, Judge.
Ah, I guess I should.
Hey, just give me a minute. I'm writing down everybody. I'm Mr. Wiley, and I'm just writing down everybody. I did take a picture, but I just want to write it down.
Your Honor, Mr. Wiley will be handling oral argument from our side.
Okay, very good.
Thank you.
So it's going to be Mr. Wiley and Mr. Howard that are arguing, right?
Yes, Your
Okay.
Honor.
This is, I just got transferred a slew of cases, and so I just want to get a few basic things understood. In the DeMarais Hutton case, what
Judge, are we on the record now? Are we on the record now? Or
I'm
are
sorry,
you?
yes, we're on the record.
Okay, I'm sorry. I thought you were going to call the case, and then that's how I know we're on the record. Okay.
All right. All right. This is in the Court of Claims, and I'm going to call two cases. John DeMarais and Paula Hutton versus Board of Regents of the University of Michigan and Gretchen Pagich. Case number 2174 MZ, and also the case of Dana Telep versus Board of Regents and Gretchen Pagich, 21-73 MZ. And we have with us today several attorneys. The argument, I understand, is going to be John Wiley on behalf of the plaintiff and Thomas Howlett on behalf of the defendant. So before we,
Your Honor, excuse me, it's Timothy Howlett.
did I say Thomas? I apologize. Okay, sorry about that. All right, so before we get started, I want to understand something. What in the Telep case, what counts are presently alive? I know there was a skip in one of the cases, and there's a reference to a workers' protection in one of the briefs, so I'm a little confused. Mr. Wiley, can you help me with that?
Yes, Your Honor. In Dana Telep's case, I believe the two, and I will check to make sure we're all set, but I believe the two are discrimination on the base of age, hostile work environment. I believe it's age is still, so correct me if I'm wrong, Jim or Tim or Angelina, anyone.
No retaliation claim at yours.
No, Your Honor. The difference between the two cases, Hutton and DeMarais is straight retaliation. We voluntarily dismissed the age claim. Telep is age.
Okay, and Hutton is also straight retaliation?
That's right, Judge.
Thank you. Okie doke. Now, I just went through the materials, and I see that plaintiffs filed their initial disclosures, but I don't find any initial disclosures from the defense. Have any been filed?
I thought there had been.
Well, why don't you just check your file, and if not, then you should attend to it, because I don't have it, and I'll check here. It's not in my materials from the clerk, so that suggests it hasn't been filed, but that doesn't mean we don't miss something.
Okay, we will check on that. Thank you, Your Honor.
Okay. All righty. Do plaintiff's counsel have any preference as to whether they address all three? I would prefer you address all three at once, but if you need to separate them, you'll let me know. And defense counsel, are you okay with responding one time to all the material?
I'm fine with that, Your Honor.
Your Honor, we would probably prefer to differentiate them a tiny bit just because there's different claims and different fact patterns. However, there are similar elements. The first argument being on whether or not this is premature, that's the same for both. Since they're different claims and different fact patterns, we can't really group them together. I'm trying to do them at the same time though, back to back, if you prefer that.
Why don't you go ahead and do one and then do the other, and you can indicate what overlaps and what's unique about the case.
Okay.
Okay. Well, Mr. Wiley.
All right, Your Honor, if you don't mind, I'll start with Dana Telep, which is
Sure.
case number 21000073MZ.
Ready.
So, Your Honor, as you've noticed, we've submitted a supplemental brief in this matter, given the recent press release by the university president, Mary Sue Coleman, addressing issues with sexual and gender-based misconduct. Now, we believe that was important given the culture that we believe that these terminations stem from, a culture of gender and sexual misconduct and bias. That would be Further noted by Exhibit 1, I believe in both cases, but Exhibit 1 being a draft memorandum from some of the highest ranking women officials at the University of Michigan, outlining how they believe that the long-term female employees have been essentially outed with really no notice, no history of disciplinary record, and simply replaced by either males or younger females. And those individuals being Carolyn Cole Brown, Sean Dwyer, Linda Laren. They addressed that memorandum to Dee Hunt, the head of HR, outlining these issues. And we believe Ms. Telep, plaintiff in this case, fell right squarely within that culture of bias against longtime female employees. She had been working for the university for over 20 years, no history of disciplinary record, whatsoever. And all of a sudden she's let go under this, restructuring where she had more experience, she had more translatable skills, and she had more ability to take on a role, whether it be at Livonia, Northville, Brighton, any of these locations. And they simply decided to get rid of her and give her job duties and responsibilities to younger employees. That's supported by the affidavits in this case by current and former U of M employees, stating that essentially everyone who was not let go was younger or not a female. And we believe that Ms. Telep's termination in this case falls strictly within that pattern and culture.
Mr. Wiley, can you tell me a little bit about, again, I get the case is confused. Was there what was the attempt to relocate or transfer, if any, in this case?
So it's my understanding there was really no attempt to relocate or transfer. So originally, and maybe you're speaking to this, originally Ms. Telep had been asked to take on duties at two separate locations at once without any increase in pay, which, like any employee should in that situation, refuse to do so because they're not receiving any more benefit for their work. She had already been doing the scheduling duties as well as a few other duties at Livonia, and Ms. Pajak in this case.
I'm going to use that argument when they ask me about getting paid for the court of claims.
I will gladly represent you.
I don't need to make life.
Might have a little bit of a conflict, but so essentially she was asked, to take on these duties at Brighton, and she said, I appreciate the offer, but I can't overextend myself like that. And ever since that offer, there was really no, chance for her to get transferred to Brighton, even though she approached them, upon hearing that Livonia was closed. And, to further the point here, the whole closing of Livonia was done in a way that really left the employees out to dry. It was announced that they were closed, and they went to the Board of Regents to protest that. And the board told them they actually weren't being closed. So, and then obviously they ended up being closed later on. So the opportunity for these employees to really get a chance to make their case to get transferred, it essentially was just left up to the management of who got transferred and who didn't. And it turned out that there was a pattern upon who retained their jobs and who got riffed. And it was the older employees, the older female employees that were let go, and the younger, less expensive employees were retained to do the jobs. But Ms. Telep in this scenario was trained in multiple facets of the university. I mean, there's tens of thousands of employees and jobs in the university that she knew how to do: payroll, scheduling, OR, and she was never really afforded the opportunity to transfer anywhere, even though she had been offered that position of the Brighton scheduler, not a year prior. And obviously, the administration believed that she had the skills to do that on top of all the other jobs she was doing. But that was never offered once she was ultimately terminated.
What is your response to the argument that you got the three-step McDonnell-Douglas issue, that there's a legitimate reason and, show me pretext? So
for that, there's the fact that it was a legitimate, closing down a location would be legitimate, but we don't believe that was the motivating factor behind her specifically being let go. Not everyone at Livonia lost their jobs. A lot were transferred to other locations, like I said, Brighton, Northville, or East Ann Arbor. And the fact that Ms. Telep was not transferred, being extremely high on the seniority list, being extremely high on the transferable skill list, would indicate to us that the closing of Livonia was pretext to get rid of her, but that was not the true motivating factor behind it, that being her age and the fact that she was an older woman. And you want to talk a little bit about the argument specifically as to hostile work environment, or you think it's the same? Your Honor, the hostile work environment stems directly from the treatment that Ms. Telep received from specifically Ms. Pajak, who was her direct supervisor, as well as a few other people, but mostly Ms. Pajak, who, after she denied that transfer to Brighton, Ms. Telep began to receive more and more work. There was multiple people who either retired, transferred, or were let go, and no replacement for them was hired. And it just so happened that every time someone left, Ms. Telep received more and more duties. And through the depositions and through the deposition testimony, it didn't seem that there was a strong grasp on what her actual job duties were. She was performing job duties that were outside of her job title, but not doing some that were inside her job title. And they just kept using the excuse of, well, it's within your job title, and kept piling more and more job duties on top of her, even though she hadn't been doing those for the past 10 or 15 years. She had to stay late, work on the weekends, learn new skills that she didn't know how to do. And when she would ask for help and someone would offer and say, yes, I can, lighten the burden and help you out, Ms. Pajak would come in and say, no, Dana has to do these things. Dana has to do these, even though, the other person offered to help or to lighten the load, and it wasn't affecting the overall work environment of Livonia. Ms. Pajak kept coming back and saying, Dana has to do these things. Dana has to, this is her job. And we believe that the piling on of duties and, after the rejection of handling the OR duties at Brighton as well, would lead to a hostile work environment that Ms. Telep felt she was being targeted, given her status as an older female, especially given the environment and culture of U of M at the moment.
Anything, you want to talk about any other issues? And you mentioned the discovery status, and we kind of went past that.
Yeah. So, and I can address that, after Mr. Howlett, but just in brief that, the first argument they brought that this was premature, that discovery was closed, but, our argument is simply that there's no reasonable belief that any more discovery will take place or anything will be found. And like that, there hasn't been any discovery since we brought this motion, a month and a half ago. There's been no more deposition notices, no more discovery documents or interrogatories. So the fact that there is still discovery period open, but there's no discovery ongoing. So it's just a tactic against plaintiffs to prolong the process.
Okay.
And that's all I have to address right now.
Okay. And you want to talk about Mr. DeMarais and Ms. Hutton as well now, or you want to wait for his response? It doesn't matter to me.
Just for the sake of, keeping it clear, I'd prefer to just do it after, if that's not a problem with you.
All right, Mr. Howlett, let's talk about, if you would respond to the argument on Telep.
Thank you, Your Honor. Well, first on the termination, it's undisputed that Livonia was closed. It's undisputed that everyone was riffed. It's undisputed that Ms. Telep was terminated because of the RIF. And I would direct the court's attention to Ms. Telep's deposition that was submitted as an exhibit by plaintiff on pages 29 and 30. Question, the reason you were let go is because of a RIF, correct? Correct. And the RIF was because Livonia was closed, correct? Correct. Do you believe they closed? Do you believe they closed to Livonia because of your age? No. So you were let go because of the closing of Livonia and the RIF, correct? I was let go because of the closing at Livonia. I was not placed in another position because of my age. The termination was because of the RIF, correct? Because Livonia closed, correct. So your only complaint is that you were not placed in a different position, correct. The I want to clarify that they didn't give Ms. Telep's responsibilities to any other employee. Her job disappeared, as did everybody else at Livonia. So the job she was doing was clearly not done by anyone else. Nor is there any evidence that there was an opening in Brighton to move her to at the time Livonia was closed. So in her deposition, we covered 4 lateral positions because there's no bumping here. Just because she can do other jobs within the university, she doesn't have a right to bump people who are in those jobs. The RIF policy requires her to look for opening positions. and she testified to 4 positions. 2 were canceled and never filled. 1 she didn't apply for because she was part-time. The other was an administrative position and she didn't apply for it. So there are no positions that she could have moved to, so there couldn't be age discrimination in that decision-making. Additionally, there's no evidence that Ms. Pajic had any role in any of transfers to those positions. There were 3 people who were placed in different positions. Every one of them was a patient services associate position, and every one of them
What associate position?
patient services associate position, I'm sorry. And all 3 of them were placed in patient associate service positions. So Ms. Telep may or may not have been able to do that job, but it wasn't her job. The people who were laterally moved to that job were moved to the same identical position they had at Livonia. There's no evidence of any identical position that was open that she could have been moved to, other than the lateral positions we talked about that were either never filled or she didn't apply for. As a result, there's no evidence that age was a factor. The 3 were not similarly situated to her because they were moved to the identical position that they already had. In terms of the harassment, it's undisputed that she had an administrative position. It's undisputed that 2 people who had administrative positions in Livonia left. It's undisputed that Ms. Pajic applied for a replacement for at least one of those positions. It's undisputed that that request was denied, and the duties were given to Ms. Telep. And Ms. Telep testified in her deposition that the jobs were given to her because she had admin in her title. The duties assigned to her had nothing to do with her age. It was that she was the last person standing who was had an administrative position. She claims that the harassment was because she received certain emails. Every one of those emails were related to her work and work assignments. They had nothing to do with age. The performance evaluations that we referenced in our brief reflect that she acknowledges these responsibilities were hers. To quote her, she said, "I've been able to learn all these new duties along with maintaining my current role of HR schedule." And she was doing well in those jobs. The evaluation indicated she's become very efficient with her new responsibilities. And she was given the opportunity to give up the scheduling, and she said she didn't want to. As a result, there's no evidence supporting that either her failure to get a job after her position was eliminated was related to age, or that there was any harassment related to age. And because of that, we think the motion should be denied, even if the court decides that it's timely.
Before, one thing I don't want to forget also, just as housekeeping, where are we at on mediation in this case? Has the mediator been selected?
No, we have an order pending, Your Honor, that by April 4th, we have to submit to the court an agreement on a mediator if we can agree. And then I think it's a cutoff of August 4th.
Yeah. Right. So, Mr. Howland, can I go back then to Mr. Wiley for his response to you on Telep, or you got more to say about it?
No, I'm fine, Your Honor. Thank you.
Thank you, Mr. Wiley.
I may have more to say later.
Okay, so Mr. Howlett laid out what sounded like some reasons why Ms. Telep ended up where she ended up. But why isn't there a question of fact?
You're muted. You're muted.
I apologize. I should not be making that mistake at 26 years old. So just a few things, to address that. So with regards to her job duties, and without delving too much, into the office politics of Livonia, there was many factors of why she didn't want to give up certain duties, and they had to do with the fact that employees believed Ms. Pajak was purposely scheduling things that should be scheduled at Livonia to another facility in order to close Livonia. This is supported by doctors' letters of some of the doctors that perform surgeries at Livonia, saying that they need to schedule these at Livonia. Why are they being moved? So the fact that they offered to get rid of the OR scheduling was seen from Ms. Telep and many other employees there as a strategy to essentially close Livonia down.
Why is eliminating surgeries in furtherance of a goal to close a facility? I'm missing that. Why that is evidence that favors you?
Yeah. So, well, it's evidence to the fact of why Ms. Telep didn't want to give up the OR scheduling duties, because she'd been doing it for so long. There was a belief that Brighton was a new facility that Ms. Pajak helped opened up. She wanted that to look very, very busy and scheduled more and more things over there. So there was a belief among the staff at Livonia that she was purposely moving things that were more convenient, that people wanted at Livonia, that should be at Livonia, to Brighton in order to make Brighton busier, look more profitable, with the ultimate goal of shifting everything over. But like I said, that's more office politics, but that does explain why Ms. Telep didn't want to give up that duty. And yes, Ms. Telep was doing fairly well, and her performance reviews show that she was handling these responsibilities, but that doesn't mean that they weren't, piling on top of her and that she wasn't looking for help with those. There are multiple instances where she reached out for help from other individuals. And like I said before, Ms. Pajak was specifically telling Ms. Telep that she had to perform those duties, even though they hadn't been ones that she performed in the past. And like I said, earlier, Ms. Telep's duties and her experience allowed her to be a scheduler, to do payroll, to do any type of administrative duties that with Livonia closing and Brighton taking on more responsibilities. The belief was that there was a need for more employees at Brighton, and Ms. Telep had been offered the scheduling duties at Brighton, less than a year before. So obviously there was a need for her skill set there, and those weren't offered once Livonia was closed to Ms. Telep.
I see. Okay. All right. Do you want anything else to respond to the argument? I asked you a question, but you can feel free to say whatever you like.
No, Your Honor, that's all I have right now.
All right, well then let's move on to the other case. So just for the record, that was Dana Telep, the Board of Regents of the University of Michigan, and Gretchen Pajak, 2021-73. And now we're going to move to DeMarais and Hutton versus Board of Regents and Pajak, which is 21-74. So Mr. Wiley, you're the movement. Go ahead.
Yes, Your Honor, just to get the first argument out of the way, we'll have the same argument that although discovery did not close at the time of this motion, that we believe discovery was complete and there has been no subsequent discovery. But moving on to the more substantive argument, while this happened at Livonia as well, involving some of the same parties, it's a much different case, and it's much more dependent on the actual events that happened specifically. So Mr. DeMarais and Ms. Hutton were employees at Livonia under Ms. Pajak, and there was a specific instance that is, attested to via affidavit by other employees at Livonia, in which Ms. Pajak threw what they are calling an IV bag, which is a large, bag used for IVs, heavy plastic, at Mr. DeMarais, and also took an eye pack, which is a surgical procedure pack, and essentially shoved it in Ms. Hutton's face, yelling at her for opening it wrong, even though the way she opened it was how she'd been taught at Livonia. So if someone's doing something wrong, that's an issue with how they've been trained to do something. Mr. DeMarais and Ms. Hutton both reported this to U of M. The police were also asked if they wanted to be involved. Mr. DeMarais ultimately decided he didn't want to file a police report for assault, but it did rise to that level where he was asked whether he wanted to file a police report. Essentially this went unaddressed by U of M, supposedly Miss Pajak was told that, she was going to come apologize and have this meeting with them. According to Mr. DeMarais and Ms. Hutton, that never happened. There was no apology. There was really no recourse for what essentially was an assault, on U of M grounds. And, given the fact that they complained about Miss Pajak, who, ultimately was in a position of power, it's believed that they were retaliated against for their complaints, and that would fall under, the exception to at-will employment in the state of Michigan for, reporting issues of public policy, that being an assault on U of M campus. Further, Ms. Hutton had a specific instance where she was at a training session, and there was the discussion of guns in the workplace, and she brought up that her boss carried a gun, and the belief was that Ms. Pajak carried a gun, and the belief was there because Ms. Pajak told people that she carried a gun, that she was always packing, quote unquote. And so Ms. Hutton brought this up to campus security, who followed up with her, wondering what the situation was. A complaint was made, and again, it went nowhere. There was really no resolution to it. There was an issue where there was one person in HR who was addressing this, who left the position, and a new person came into the position and didn't address it at all. That being the first instance and the gun instance. So Mr. DeMarais and Ms. Hutton both made complaints against Ms. Pajak, and again, Mr. DeMarais and Ms. Hutton both had solid work performance records with no issues of complaints. And then again, once that rift came down, they were not placed in any new position, that they desired for. Now, Ms. Hutton ultimately did end up receiving a new position within the university, but they were not transferred, upon the rift. And Ms. Hutton actually was terminated before the closure of Livonia. So Mr. DeMarais and Ms. Hutton both, fit into that category where they complained about a supervisor. There obviously was no real recourse to that issue. And then they believe they were retaliated against, given that supervisor's position of power when they were looking for new positions within the university.
Okay.
Thanks.
Thank you. Mr. Howell, in this response, just would you respond to the issue about discovery, whether or not you still assert that that's a reason that this isn't right to consider the motion?
Well, I think it's right. I don't think there are discovery issues on the DeMarais and Hutton case, because I think it's right for it to be dismissed in our favor, frankly. You want me to respond substantively, or? Thank you.
Yes, please.
So as plaintiffs concede now, this is a straight retaliation case. The complaint, retaliation, was a retaliatory discharge for reporting violation of company policy. And it's kind of morphed in now to it's a retaliatory discharge against public policy. And the position plaintiffs are taking is that they exercised a right explicitly conferred by legislation, because they complained about conduct by Ms. Pajak that could constitute assault, or complaints regarding unlawful carrying of concealed weapon. And I'm not going to, clearly we disagree with their characterization of that, but it's not really important for purposes of this motion. What plaintiff is claiming that, plaintiff in their brief say they're not suggesting that they're entitled to summary disposition based on U of M's internal policies. Instead, their claims violate OSHA and MyOSHA workplace safety standards and weapons violations under Michigan law. And we cited established Michigan law that the Michigan Whistleblowers Act preempts a public policy claim for violation of Michigan law. And not seen any authority that would counteract or contradict that argument. So first of all, would be a whistleblower case, and there would be no claim for termination violation of public policy. So that's
Was
one
the
argument.
more than 6 months out?
Yes.
I mean,
The second reason that the claim fails is there's no causation with these reports that they made connected to their termination. One, again, it's undisputed that Livonia was closed. It's undisputed that everyone was riffed. Ms. Hutton applied for one position, she didn't get it, and then left for outside employment. Ms. Pajic denies she had any involvement in that decision about Ms. Hutton not getting the position, and there is no evidence that Ms. Hutton or Ms. Pajic was involved at all. Mr. DeMarais applied for, there were no jobs in his specific position, but there were some jobs he applied for that he thought he might be able to do. He testified that he specifically only selected jobs that Ms. Pajic would have no involvement with. There's no evidence that she would have had any knowledge or involvement in any of the jobs he applied for. So plaintiff's motion should be denied. But we also think, Your Honor, this is a rare case where summary disposition should be granted to us at this point under 2.116 I2 because we are entitled to summary disposition because of the preemption argument. And because of that, it's clear that the Whistleblower Act would apply to these claims. It would preempt any public policy claim. And so we can file our own motion if the court wants us to, but that's where we believe we are.
okay, thank you. Mr. Wiley, response?
Yes, Your Honor. So, it's plaintiff's position that this is not a whistleblower's claim because, as I stated, that Mr. DeMarais, flat out refused to file a police report. And under the whistleblowers, there has to be a complaint made or the employee is about to make a complaint made to a public body, that being a regulatory body, a police, some sort of public body set up to do that. And this was an internal, HR complaint to Michigan Medicine HR. So this would, because they wouldn't be able to bring a claim under whistleblowers because they never made a complaint to a public body or were not about to, and there was no thought they were about to, that this would have to be brought under public policy. And it seems that either way that it was argued, it would be obviously argued the opposite way by defendant, that if we brought a whistleblower's claim, they would claim just what I said, that there was no complaint made to a public body. And now that we bring a public policy complaint, that they'll argue that it's preempted by whistleblowers, which is not an uncommon argument. But in this one, it seems pretty solid that since there was no complaint made to the Michigan legislative body, to MIOSHA, to anyone of that standard that would have had whistleblower protection, and this would fall under the public policy exception.
What about Mr. Howlett's argument that there's no evidence that of causation, that any of these complaints were related to ultimately what occurred?
Well, it would essentially be the same argument of circumstantial evidence, of a discrimination claim. Obviously there's no email that says, you're being riffed because you made a complaint about Ms. Pajak. But in this case, when you make a complaint against someone of, as high up as Ms. Pajak is, and then ultimately you're let go without, getting a new job within the university, then there is this circumstantial evidence that that was the reason why you were let go, and that you weren't afforded a new position, especially given the fact that there was no, frankly, Ms. Pajak at a lot of places would have been fired for this type of conduct. And the fact that there was really even no disciplinary action, even though there was multiple witnesses that attested to the fact that this assault happened on U of M property by a supervisor to a subordinate, and there was not even as much of an apology. So the circumstantial evidence there would be that U of M's interested in sweeping this under the rug and allowing these terminations to go forward, to put people in place that essentially raise less noise about the problems going on.
So just to be clear, the retaliation claim is not based on any complaints made relevant to age, gender. It's not an ELPA retaliation claim. This is the public policy retaliation claim as you've pled it.
Yep.
Okay. Okay.
Yes.
Mr. Wiley?
I'm just saying, yes, that is correct. And that's it.
All right. Very good. Well, I appreciate
Honor,
the argument. Yes.
May I respond, please?
Yeah, you can give me a little response, but if Mr. Wiley wants to come back again, I'll let him also,
No,
and then
I understand that, but the Whistleblower Act does apply because she complained to state employees. The University of Michigan is a state institution under the Constitution. She complained to the security department, the police department of the University of Michigan. And she complained to the HR department, and they are covered by the Whistleblower Act. So, thank you.
Wiley, any additional response?
Only that I would disagree with that, and that would be it.
Very good. Well, I appreciate everyone coming in for argument. Is there anything else anybody needs to cover before I close out here? All right, very good. So I will review the materials again and hopefully issue an opinion, within 21 days, I would hope, and at least get things clear before you are moving very far along mediation or not. Okay.
Thank you, Your Honor.
Thank you.
Thank you,
Yeah,
Judge.
is anybody ordering the transcript before everybody signs out?
No, ma'am.
Okay.
Thank you.
Thank you.
Very much.
Bye-bye.
Bye.
Tim, I'll call you.
Okay, Jim, thanks.
Okay.